private members' business, resuming debate at second reading of Bill S-230, Drug-Impaired Driving Detection Act. On behalf of Mr. Reyes.
Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker, and thank you for the opportunity to speak today. I can indicate that I will be speaking against Bill S-230. I want to acknowledge that the bill is well-intentioned, and its sponsor in this chamber, the Honourable Member for Richmond Arthabaska, is to be applauded for the aim of the bill, which is to address drug-impaired driving. Similarly, the sponsor of Bill S-230 in the other place, the Senator from Mille-Île, must be recognized for having had the same laudable aim when he initiated this bill. Our government understands the significant impact impaired driving has on the safety of our roads and highways, including drug-impaired driving. We are firmly committed to strengthening appropriate laws and enforcement measures to deter and punish serious offenders on the road. That is why, while we support the intentions behind the Senate public bill, our government has brought forth its own comprehensive regime to drug-impaired driving, which, as you know, is reflected in Bill C-46. And this is part of our approach, and it is consistent with the work that we are doing with regard to strengthening the strict regulation and the legalization of cannabis. The issues to be resolved in developing a comprehensive strategy to combat drug-impaired driving are complex and are too difficult to address through amendments to this non-government Senate public bill. Bill C-46, on the other hand, fully addresses the concerns we have with S-230. Bill C-46 will create one of the toughest regimes against drug and alcohol-impaired driving in the world. It will improve the detection and prosecution of drug-impaired drivers and build on existing measures by authorizing the police to use new tools to better detect drugs in drivers and by creating new driving offences for being over the legal limit for certain impairing drugs. Police will also be able to demand an oral fluid sample at the roadside if they suspect a driver has a drug in the body. This will be similar to the current method of testing for alcohol at the roadside with an approved screening device. In this light, the Senate public bill's proposals are flawed and would be highly problematic for a number of reasons. Bill S-230 proposes to authorize police to demand from deliver to an oral fluid sample on a drug screener at the roadside. The officer following a lawful stop first must reasonably suspect that there is a drug in the driver's body. Of course, the Criminal Code already recognizes police to demand from a driver breath sample on an alcohol screener at the roadside if the officer suspects that there is alcohol in the driver's body. It is easy, therefore, to understand the interest in a similar screening device for drugs. However, the reason why the alcohol screener is so very useful is precisely because we have the crime of, quote, driving with a breath alcohol concentration exceeding 80 milligrams of alcohol in 100 milliliters of blood, close quote. A fail on the alcohol screener leads to further police investigation of a possible over 80 offence. However, unlike our government's Bill C-46, Bill S-230 proposes no similar legal limit for any drug. Therefore, the only charge available to police would be driving while impaired by a drug, which requires strong evidence of actual impairment. An oral fluid drug screener does not provide any evidence of impairment, but only the presence of a drug. And for this reason, I believe the bill's usefulness is minimal. To explain further, an oral fluid drug screener proposed by Bill S-230 could only be used, among other factors, to help police develop the reasonable grounds to believe that a drug-impaired driving crime has occurred. The drug screener result could not be used, as it is in the UK, for example, to further investigate a drug legal limit offence because, until C-46 is adopted, there is no drug legal limit offence in Canada. In the UK, drug screeners are very helpful in investigating the legal limit offences for THC, the active chemical in cannabis, and for cocaine. These are the two drugs that are most prevalent in drivers and that are screened by the UK drug screeners. In contrast, under Bill S-230, a drug screener could only be used in Canada as an investigative tool in a driving while impaired by a drug investigation. Despite the fact that Parliament had enacted a driving while intoxicated by a narcotic offence in 1925 and a driving while impaired by a drug offence in 1951, drug-impaired driving investigations remained a huge challenge for police until 2008. This challenge of investigating a drug-impaired driving offence was not unique to Canada. In the 1980s in the United States, a series of tests were developed that helped to show impairment. This knowledge was used to develop a standardized field sobriety test for screening at the roadside, plus a drug recognition evaluation, or what we commonly refer to as the DRE, which is a broader series of tests that is conducted at the police station. In the early 1990s, some officers from British Columbia were trained in SFST and DRE, and they commenced using these tests on those suspected drug drivers who were willing to participate on a voluntary basis. In time, many drug drivers simply declined to participate. In 1999, the Standing Committee on Justice and Human Rights recommended that experts consider what tools might be used by police to better investigate drug-impaired driving, and SFST and DRE were put forward. After several unsuccessful attempts, Parliament in 2008 enacted authority for police to demand that SFST tests be performed by a driver at the roadside. Before making the demand, the police officer must have reasonable grounds to suspect that there is a drug or alcohol in the driver's body. The 2008 legislation also authorized the police to demand the DRE series of tests at the police station if the officer at the roadside has reasonable grounds to believe that the driver is impaired by a drug. This belief is based on observations at the roadside, including the driver's performance on the standardized tests. The DRE testing is conducted by a specifically trained officer who is called an evaluating officer. It includes tests of balance, the ability to perform divided attention tasks, and physical measurements of pulse, eye reaction to light, and muscle tone. If the evaluating officer at the police station identifies a drug as causing impairment, that officer may demand a bodily sample of urine, saliva, or blood to confirm or eliminate drug presence. At best, under Bill S-230, a drug screener might help police to form the necessary grounds to make a DRE demand. This would be a tool that could be used at the roadside with or without SFST. Again, the police would be investigating a driving while impaired by a drug charge. This contrasts with Bill C-46 and with our experiences in the UK, where drug screeners are very, very helpful in investigating the legal limit offences for THC and for cocaine. Personne ici
No one here is surprised that drug-impaired driving is a growing problem in Canada. This trend has been confirmed by the Jurastat report called Impaired Driving in Canada 2015 from the Canadian Centre of Justice Statistics, published in December 2016. The number of charges for drug-impaired driving increased fourfold or almost in the few years followed the implementation in 2008 of new tools under the code to help police officers investigate drug-impaired driving. As the cannabis reform approaches, drugs at the wheel are a growing concern among Canadians. From what I'm told, some surveys have revealed that the notion that cannabis does not impair driving is especially prevalent among young drivers. It is possible that young drivers will compare the effect of alcohol to that of cannabis when it comes to driving. However, it must be known that these two substances are absorbed, distributed, and eliminated very differently by the human body. Furthermore, their effects are not the same.
So now we have a project that is being successfully completed here on the government side, Mr. Speaker. We have that project in Bill C-46, and it is looking very, very constructively at how we can use these new devices, like the oral fluid drug screeners in the field, and we are using that bill and the robustness of the regime that it proposes to ensure that we are keeping our roads safe and at the same time reducing the access to cannabis to our children. As I have indicated, having a drug screener legislation without drug legal limit legislation does not take us very far. Therefore, I intend to vote against Bill S-230. I support our government's position, which is far more comprehensive in Bill C-46, and I encourage all members in this chamber to do the same. Thank you, Mr. Speaker.
Resume debate. The Honourable Member for Belleuil-Chambly. Thank you, Mr. Speaker. I would like to start my speech by thanking the member for Richmond-Arthabaska, who sponsored this bill from the Senate. I had the opportunity to work with him on the Public Safety Committee. I also know that he was the director at a school. Regardless of our ideological differences, I can say that I believe in his sincere efforts to improve public safety. Because, Mr. Speaker, let's be clear from the beginning that regardless of our opinion or the approach that we support to eliminate the problem of impaired driving, we all agree in this House that it must be done. It's especially important, and we all recognize it, with statistics that demonstrate an increase of impaired driving, namely because of marijuana. For that reason, Mr. Speaker, I support the bill, at least to bring it to committee, so that we can hear a bit more about it. My previous experience was not especially convincing. I'm talking about another bill. You'll have to forgive me, I don't remember the number. It was another bill having to do with random alcohol testing proposed by a Conservative MP. During the study of that bill, I think a lot of the testimony could apply to the discussion of the bill before us today, as well as other factors that we should consider. First of all, we've just heard the Parliamentary Secretary talk about some of the problems. The bill simply uses criteria that are present in the criminal code regarding impaired driving due to alcohol and is applying them to drugs. We're talking about the recognition by the police officer who intervenes. That's not a big change. The problem is that what we see in the criminal code, the 0.08 that we know for alcohol, in some provinces the 0.05 for roadside safety. We know that in this bill, there's no mention of the presence of THC and the blood alcohol concentration that would be able to measure how much marijuana had been consumed. That's a significant lack in this bill. And why is that? Because we're relying on visual indicators, the person's behavior, physical indicators that might be present. That's problematic because there is a lack of training. The men and women in uniform who protect our safety do their work well, but when it comes to the government bill on legalization of marijuana and driving while under the influence, well, there's a lot of work that remains to be done to offer more training to our men and women in uniform to make sure that they can correctly recognize the physical symptoms, if you will allow, to detect a case of drug-impaired driving. That's something that's extremely important. In the bill, there's mention of saliva tests. The problem is that experts tell us that the presence of THC can be detected in bodily fluids many days, even weeks, after the drug has been consumed. In this case, we're talking about marijuana. The problem, Mr. Speaker, is that without a set prescribed concentration outlined in the law and a correct test, we could end up in a situation where someone who smoked marijuana weeks ago, or days ago, many weeks, I'm not sure of the science around that, but let's say several days previously, and there could be the presence of THC in that person's body. But finally, the level of concentration would not be high enough to be deemed criminal. For example, if we look at Colorado, which set a limit, a precise limit, a blood alcohol concentration for THC among people who are driving impaired. Without that, it's a problem because we could end up in a situation where we could arrest people who, in the end, were not impaired. They had simply consumed a substance previously, and that is extremely concerning.
The other thing is the question of the capacity of these tools to accurately measure what it is that the police seek to measure, and that is the THC level or concentration in the blood. And when the Public Safety Committee looked at this question with breathalyzers and so on, there were some members who asked this very question about the reliability of drug detection devices. And many witnesses, including those speaking on behalf of the police, said that although there was still no best method, most reliable method to measure THC concentration in order to be 100% sure that you're arresting the right people. So when you want to fix a problem, you have to make sure that you find the right solution. And that's one of the problems with S-230. And the same problem cropped up in previous situations. You need to find a comprehensive approach that deals with multiple facets of a problem. For example, there were some witnesses before our committee who pointed out the same shortcomings as there are in this bill when you talk about breathalyzers and the onus of proof that the police bear. When you look at all the problems, you realize that you can't just deal with one thing. You have to take a holistic and comprehensive approach to road safety. For example, there's education, awareness raising. We have to look at other jurisdictions that already have tougher legislation along the same lines, including U.S. states. So we need to look at what they've done in choosing the best approach for us to take. When you look at the U.S., in Washington and Colorado states, specific THC concentration levels were set in the legislation, and that's what needs to be measured in the blood before someone can be arrested. In Oregon, they took a different approach. They just use visual tests. For example, the police officer who pulls someone over can visually ascertain whether or not the person appears impaired and then proceed to other tests if necessary. And there are other jurisdictions in Great Britain, for example. They have taken somewhat more specific measures of concentration. So, by way of conclusion, Mr. Speaker, I'd like to congratulate my colleague for sponsoring this bill here in the House of Commons. As I said at the outset, of course there's no debate around the willingness of everyone here in the House to try to eradicate this problem. Too many of us have been affected by this problem, by the deaths that have resulted from impaired driving. But we want to make sure the job is done right. We have to make sure that we bring the numbers down. Those numbers have shot up too significantly, but the approach has to be a comprehensive one, and we have to realize that we can't just have set phony levels. We have to make sure that we set the right concentration levels and that those be specific and measurable, reliably measurable. And my last point, Mr. Speaker, is that this reminds us all of the need for private members' bills coming from senators or members. Despite everything, the Liberals have a lot of problems with legalizing marijuana. The fact remains that there have been lots of consultations, lots of things have been done in a kind of bungled way. There wasn't enough consultation with the provinces, or it wasn't done well enough. There's still a lot of work to be done, and this bill points to that problem, but it's not a solution in and of itself. So we're going to vote in favor of this bill so that it gets referred to committee, but I look forward to what can come of that. Thank you.